In 2011, thousands of small business owners across America, from local coffee shops to family-owned motels, opened their mail to find a legal nightmare. They were being sued by a company they had never heard of for using a technology they didn't even know they had to pay for. The technology was Wi-Fi. The company was called Innovatio IP Ventures, and they weren't asking for a small licensing fee. They were demanding up to $2,500 per location. Their argument was simple, yet terrifying. They owned the patents that made wireless internet possible, and every business providing Wi-Fi to its customers was infringing on their intellectual property. This wasn't a targeted strike against tech competitors. It was a legal carpet-bombing campaign. Innovatio sent out over 8,000 demand letters to end users. Their strategy relied on a brutal economic reality. Fighting a patent lawsuit in federal court costs millions of dollars. For a local bakery or a hotel franchise, paying a $3,000 settlement was simply cheaper than hiring a corporate defense attorney. It was legally sanctioned extortion, designed to fly under the radar. But Innovatio made one fatal miscalculation. They assumed the small businesses would just pay out of fear. Instead, they woke up the giants. By targeting the customers of tech titans like Cisco, Motorola, and Netgear, Innovatio forced the manufacturers to step into the courtroom to protect their users. What followed was a multi-million-dollar legal war that exposed the dark side of intellectual property and ended in one of the most humiliating financial settlements in corporate history. To understand how a company can claim to own Wi-Fi, you have to understand the business of patent trolls. Innovatio didn't invent the wireless router. They didn't write the code. They simply bought a portfolio of 23 patents from companies like Broadcom and Intermec. These patents covered the fundamental technology of the 802.11 standard, the universal traffic rules that allow your laptop to talk to your router without crashing. When an engineering standard like Wi-Fi is created, it requires thousands of different patents to work together. This creates a dangerous legal trap known as royalty stacking. If every single patent holder demanded a massive percentage of the final product's price, building a computer or a smartphone would be financially impossible. The entire tech ecosystem would collapse under the weight of endless licensing fees. Because this technology is the backbone of the global internet, the original owners of these patents made a legally binding promise to the Institute of Electrical and Electronics Engineers. They promised to license their patents under RAND terms, reasonable and non-discriminatory. This is the cornerstone of modern technology. If your patent becomes an industry standard, you are guaranteed millions of customers, but in exchange, you cannot extort them. You must charge a reasonable fee. Innovatio ignored the word reasonable. They believed that because Wi-Fi was essential, they were entitled to a cut of the revenue from every hotel, supermarket, and cafe that used it. They treated a standard essential patent like a blank check. When the case landed in the Northern District of Illinois, Judge James F. Holderman was tasked with answering a billion-dollar question. What exactly is a reasonable price for the airwaves? The trial became a massive multi-district litigation. In standard patent disputes, courts often use the Georgia-Pacific factors to determine royalties, a complex legal test that can easily inflate the value of a patent. But Judge Holderman rejected this. Instead, he implemented a rigorous top-down valuation approach. He didn't look at how much money the hotel made, but rather looked at the total profit pool available for all essential Wi-Fi patents combined, and then calculated Innovatio's specific slice of that pie. Innovatio legal team tried to justify their massive demands by pointing to the overall value of a wireless network to a business. But the manufacturers fighting back pointed out a massive flaw in Innovatio logic, the doctrine of patent exhaustion. Innovatio was trying to charge the end users, the hotels and coffee shops, for patents that had already been licensed to the companies manufacturing the internal Wi-Fi chips. Judge Holderman saw right through the strategy. He ruled that the royalty shouldn't be based on the profit of the hotel or the price of the router. The royalty had to be based strictly on the profit margin of the Wi-Fi chip itself, a component that costs only a few dollars to make. The final verdict was a masterclass in financial justice. The court determined that the fair, reasonable, and non-discriminatory rate was not $2,500. It wasn't even $1. The rate was set at exactly 9.56 cents per device. In a single ruling, Innovatio empire collapsed. A company that spent millions in legal fees trying to extort the American hospitality industry was told their ultimate weapon was worth less than a dime. They eventually settled for pennies, proving a fundamental law of corporate finance. Attempting to exploit a global standard will always cost you more than you can possibly gain.